Heidi Thole. I'm an intellectual property attorney at Reinhart Van Duren, and I am back with a brand new episode of the RIPL Effect. September brings with it many things: the start of fall, return to school, and some long anticipated sporting events. Many of you may remember the Ryder Cup from when it was in Wisconsin in 2021, and it returns to the US later this month. The Ryder Cup is a unique and highly anticipated golf event that pits Team USA against Team Europe in a competition of high stakes, strategy, and sportsmanship to see who will take home the trophy. Unfortunately, we have to wait a few more weeks for the Ryder Cup, but I thought in the meantime, and in the spirit of the Ryder Cup, we would do a comparison of US and European Union trademark law. First up is a comparison of scope of protection. In the United States, if you file a federal trademark application and are approved for registration, the registration will give you exclusive trademark rights throughout the United States. This is pretty similar to other jurisdictions. In most cases, you apply in a specific country for trademark registration and are granted protection within that country. The EU is a little bit different. You can file one single trademark application, and the resulting registration will protect you in all EU member states. It's a pretty good, about 27 for the price of one deal. However, there are some important things to consider. An EU trademark registration only provides protection in countries that are EU member states. That means countries that are not in the EU, notably countries like the UK, Switzerland, and Norway, would not be protected under an EU trademark registration. This is important if you're considering on applying in the EU and you may have business in some of these member states as well as non-member states. Next up is a comparison of the basis of trademark rights. In the US, trademark rights are based on use. That means as soon as a trademark owner uses a trademark, they have some common law or unregistered rights in the mark. These rights can certainly be supplemented and strengthened by a federal registration, but the key core for trademark rights is use. This is very unique to the US and pretty different from how trademark rights are handled in the rest of the world. By comparison, the European Union is a first to file jurisdiction. This means that the person who gets first to the trademark office to file an application for registration is the one who owns the trademark rights. This means that even if you are using the trademark in the EU, but you don't have a registration, technically you don't have any rights. This is a really big point of differentiation, particularly for businesses that are used to operating in the US, where you have some trademark rights based on use, versus the EU, where even use might not provide you rights. Third up are differences in the application process. The US Trademark Office uses a pretty rigorous trademark application review process. They review applications for, among other things, confusing similarity with other prior registrations and prior pending applications. This means that if an examining attorney at the trademark office believes your applied for mark is likely to cause confusion with a trademark in a prior registration or prior pending application, your application may be refused and you may have to submit additional arguments and evidence in support of registration, or it may be difficult or even impossible to register your trademark. The European Union trademark registration process is a little bit different. The European Union Intellectual Property Office won't technically reject an application based on a prior registration or a prior pending application. This can make the application process a lot more streamlined and potentially quicker from the viewpoint of the applicant. However, it does put some more burden on a trademark registration owner to take active steps to protect their trademark rights. Although the EU won't reject an application based on prior registrations or prior pending applications, the European Union IP office still does a search and notifies owners of prior registrations or pending applications if they believe that a newly filed application might be similar to the registered mark or the mark in the prior pending application. It is then up to the owner of the registration or the prior pending application to actively assert their rights and oppose the application if they believe there is a potential conflict. So while it might be a little bit easier or streamlined to get through the application process in the European Union, trademark registration owners do have a bit more active duty to police and oppose potentially conflicting marks once they do own that trademark registration. The fourth point of comparison is the trademark maintenance and renewal process. As we mentioned before, use is really the core and cornerstone of trademark rights in the United States. This shows up in the trademark registration maintenance and renewal process as well. The US is a little bit unique in that it requires trademark registration owners to submit evidence of continued use between the 5th and 6th anniversaries of the registration. The purpose of this is to prevent people from holding on to trademark registrations even if they're no longer using the trademark. In addition, the U.S. Trademark Office requires the owners of trademark registrations to renew their trademark registrations every 10 years. This is fairly similar to other jurisdictions, as we'll discuss in the case of the EU. However, there is an additional requirement in the U.S. With every renewal, the trademark registration owner must submit evidence that they are continuing to use their trademark. This means if the trademark registration owner is not using the trademark for any of the goods and services in their trademark registration, unfortunately, they may not be able to renew or maintain their trademark registration. If the owner of the registration is only using the trademark for some of the goods or services in their registration, then they may have to either amend their registration to delete the goods and services that are no longer offered, or potentially risk an audit from the U.S. Trademark Office. In the past few years, the Trademark Office has started to audit trademark registration renewals, meaning that they will randomly select applications to renew registrations and ask the registrants to provide additional evidence of use for some random goods and services in the registration. If they're not able to provide the evidence of use requested, then the owner of the registration has to go through and remove everything that is not in use and then provide evidence of use for each good and service that they want to keep in the registration. This can make the renewal process much more onerous if the owner doesn't take proactive steps to review their trademark registration, but the purpose is to prevent people from maintaining registrations if they're no longer in use. So with those 4 points of comparison, there are definitely differences between the filing, renewal, and rights systems in the United States and the European Union. Each has certain advantages, potential with drawbacks or additional considerations, and certain strategic advantages if thought about carefully throughout the application and renewal process. Because they both have potential advantages and additional considerations, I'm not going to declare a winner in Team USA versus Team Europe as it regards trademark law. I guess you'll just have to wait a couple of more weeks for the Ryder Cup for that. And if you want more trademark updates, stay tuned for our next episode of the RIPL Effect.